So while there were multiple settlement agreements reached with firms accused of excessive pricing in these regulations, there were a couple of widely publicized litigious excessive pricing complaints. The first was Babalegi Workwear and Industrial Suppliers, and the second was the complaint against Dis-Chem Pharmacies. Both of these cases were ultimately decided in favor of the Commission, and the firms were required to pay fines for their conduct. Babalegi's fine was overturned on appeal to the Competition Appeal Court because it had already been fined for substantially similar conduct in terms of the consumer protection laws. And this actually speaks to a greater ideological debate about whether price gouging laws are appropriate. In competition law, as a price gouging, it's not necessarily a competition issue, it's a consumer protection issue, right? This is because price gouging laws are really aimed at consumer protection and not the protection of competition, which means they may be better placed under consumer protection legislation. The discomfort of using competition law for consumer protection, as opposed to consumer welfare generally, which is the object of competition law, is also clear in the way that the tribunal assessed dominance in these cases. So broadly, in both cases, the tribunal found that the fact that Babalegi and Dis-Chem were able to charge what they did, which they wouldn't have been able to do but for the peculiar circumstances of COVID, means that they had this notion of temporary market power and were therefore dominant, which is kind of a backwards measure for dominance. You'll all know, and we'll come back to it later, dominant firms have additional obligations under the Competition Act. But both of these companies were new entrants into, relatively small entrants into a particular market. But essentially, the tribunal found that the existence of an excessive price proved, or the fact that they were able to charge an excessive price proved dominance, even if it was temporarily so. So while it's correct in principle that market power can be inferred from a firm's economic behavior, it ought to still be assessed in the context of the relevant market. So in its discussion on dominance and a relevant market, the tribunal alluded to the likelihood that in crisis situations, more than one store in close proximity to competitors, so even within the same shopping mall, could enjoy market power vis-a-vis consumers. So the approach to excessive pricing this past year has certainly been somewhat unprecedented. It remains to be seen if this will be some kind of permanent shift in the framework of the assessment of dominance. We don't think so. I think it is peculiar to COVID. But as there are some other changes to the dominance sections that we will come back to a little bit later. Right. So to move on to the next topic, which is move away from COVID completely, and Tab, we can go into the next slide. I do want to talk about merger control, what's happened over the past while, and mostly to cover issues around the public interest, but there are some other things that I'll touch on first. So you are all most likely aware that the merger regime in South Africa is what's known as a pre-notification regime, which means that you have to get approval before you can implement your transaction, and you can be fined for gun jumping or for a failure to notify your transaction when you are required to do so. This means that the Commission monitors failures to notify fairly vociferously. There have been a number of settlements during the course of the last 18 months. Earlier this year, there was a settlement reached in relation to the ETG agro products and Rand Agri matter. Firms admitted that they'd notified the transaction, that failed to notify the transaction, and they paid a fine of about R1 million. There was another fine of 1.7 million Rand, in which Kagiso Media agreed to pay a fine. So I think the message, the takeaway here is the Commission actively monitors merger activity. They are on the lookout for gun jumping. They are actively enforcing the guidelines that have developed, and fines have ranged around sort of, the 1.5 million, but there's nothing to say that they can't increase going forward. So it's just to put a spotlight on merger activity generally. So then to move into some of the substantive stuff, merger control in principle should be and is focused on the competitive assessment. And here the substantive assessment is whether the proposed merger will substantially lessen or prevent competition in a relevant market, and if so, can it be justified on pro-competitive efficiency or technological grounds? In South Africa, we have an equally important second leg of that inquiry, which is public interest assessment. And in fact, can motivate for approval of a merger that would otherwise be prohibited under the competition assessment. Conversely, a merger can also be prohibited on public interest grounds alone, as opposed to competition grounds. In other words, both the competitive assessment and the public interest assessment are equally weighted under South African competition law. So what has become increasingly critical is that due regard is paid to the importance of the public interest assessment at the outset of your transaction. So when you're considering a merger, you can't, sort of consider only the competitive effects and plunge straight in without giving consideration to a full public interest assessment. So historically, this has focused on jobs, and we'll get to how important jobs remain in this inquiry. But more recently, the effect of a merger on small, medium, SMEs and HDPs, historically disadvantaged persons, has taken on particular importance, right? So I'm going to look at a few examples of how important the assessment has become and the ways in which it has cropped up over some cases, touching on the various aspects of public interest. So the first example, maybe on the next slide, Tab, would be an undertaking that Dis-Chem made in relation to a merger. So interesting, one, they undertook to notify the Commission of any small mergers that may acquire control over the pharmaceutical market. But two, they undertook to maintain and, if possible, improve current levels of procurement, including from SMEs and HDPs, and to provide learnership opportunities. So maybe just to pause here and to recap the approach that the authorities take to public interest. The test is there an impact does the merger impact public interest consideration? And there's a range of them. And if so, is there an equally weighty or countervailing remedy that one can bring to counteract that negative impact? And so this is what Dis-Chem came up with as a way to countervail whatever impact the Commission found. Another example is sort of a dilution of ownership example. So it was in the Valaris adapted transaction. They're in software, and it was, I think, a vertical transaction. But in any event, the Commission found that the transaction would result in a dilution in ownership by HDPs at adapted, and they imposed conditions to address the concern. And so essentially, the merging parties agreed to maintain a certain level of HDP ownership, as well as to establish a trust to hold shares in adapted on behalf of co-workers. So these things have been happening, sort of fairly routinely over the past few years, where the Commission has sought to impose conditions to address the impact of public interest brought about by a particular merger. But perhaps the most highly publicized and controversial transaction to hit the news in this past year, which I'm sure you've all heard about, was the private equity transaction in terms of the Burger King matter, where Grand Parade wanted to sell its shares in Burger King to ECP Africa Fund, a private equity fund. So it was an intermediate merger. It was initially prohibited by the Commission purely on public interest grounds, right? And the ground was that the current shareholding of Burger King would decrease from roughly 68% to zero as a result of the merger. There were no employment concerns because the parties had given an undertaking that there'd be no retrenchments as a result of the merger. And the transaction didn't raise any competition concerns, right? The merging part, so it was prohibited outright, and that was the first time that we had seen a merger prohibited solely on the basis of a public interest ground where there were no other competition or employment issues. So the parties went back to the drawing board, and they subsequently approached the tribunal for a reconsideration of the Commission's prohibition. And they agreed a revised set of conditions reflecting what essentially amounted to a negotiated position between the parties and the DTIC, seeking to remedy the concerns around the effect of the merger on this new ground, this promotion of a greater spread of ownership and increasing levels of ownership of HDPs and workers in firms in the market. This agreed package wasn't opposed by the Commission, and ultimately the transaction was approved. If we can maybe just go on to the next slide, Tan, I'll just cover very briefly the kinds of creative remedies that the parties put forward. So there were things around expansion commitments, so various investments and expanding the number of outlets in South Africa from 90 to at least 150, that they would increase permanent employees, particularly HDP employees. They made commitments relating to South African suppliers involving local procurement and to provide to improve compliance with the enterprise supply development element of the merging parties' broad-based economic empowerment scorecard. There was an ESOP, employee share ownership program, to the amount, I think, 5%. They made a divestiture commitment, which we don't need to go into in that much detail, and various other commitments. Now, when it first was announced, this case caused a little bit of commotion, right, when the prohibition was first announced. I think one of the concerns raised was that prohibiting a merger simply because it leads to a reduction in HDP ownership seems to signal a change, first of all, in the Commission's approach, because usually it's this weighing up approach that I mentioned, although the outcome, as you will have seen on reconsideration, is very much this weighing up approach. You know, how do we countervail the negative impact with these creative remedies and solutions? So I think that has been set to rest, and that, you know, the Commission and the authorities generally were open to this weighing up, balancing approach. So that's a very important principle that I think we can put to rest. But one of the other concerns is that, you know, whether or not this makes it more difficult for Black shareholders to realize and exit their investments, because, you know, does it amount to a restriction on them from selling their shares to non-Black shareholders, because it would lead to a reduction in HDP ownership post-merger? There were also questions around whether or not, you know, the target firm's Black shareholders would be able to find a buyer whose HDP status wouldn't dilute the ownership and get a price. In other words, they may be held over a bit of a barrel because their pool would be relatively smaller, because the buyer would know that the seller has limited options of who it can sell to, you know, giving the buyer some more negotiating power to demand a lower price. I think importantly, the remedies in this case were fairly fact-specific, and, you know, peculiar to this case. But I think this principle is here to stay. And most importantly, I think it is still open to us to bring this sort of basket of remedies and sort of basket look, instead of looking at one particular criteria, which was the concern. And we have to carry on navigating our way through this. When the Commission first started looking at commitments around job losses and no retrenchments, we had this period of uncertainty and negotiation until it sort of settled down and everybody then understood what the rules are. And so I think that's where we are in relation to this HDP ownership issue. It's new, it is a little bit uncertain. We are navigating our way through it together with the authorities. And we have found them sort of, you know, continuing to be open to these creative solutions. What I can tell you is that it has now become fairly routine for the Commission to request information on this topic, specifically when a merger is filed. So, if there is any change in HDP ownership as a result of the transaction that you may be engaged in, you can expect the Commission to query it, to ask for further information on it. I think the takeaway message here is that merging parties must give substantive consideration to all relevant public interest concerns, potential public interest concerns, at the start of your transaction. It has to form a fundamental part of the planning, valuations, synergy, efficiency calculations, assessments. So, so that you can go in armed with a plan, so that you know what you're going into, and you can, sort of come up with these creative solutions. Okay, so you will have seen HDP ownership fairly new. This doesn't mean that jobs are no longer on the agenda. In fact, at TAF, we can go to the next slide. I think jobs will remain an important part of the public interest assessment. We expect the authorities to continue to focus on this aspect of public interest, and potentially allow mergers, particularly in the context of failing firms, that may not otherwise have gone through if they can save jobs. You'll all remember, no doubt, the Sibanye acquisition of Lonmin. The AMCU ultimately took it on appeal, and what came out of that case was really, when you're weighing up doing the merger with a small number of job losses versus not doing the merger and letting the business potentially fail, resulting in mass job losses or substantially more job losses, that the better outcome there is to allow the merger to go through and have, a smaller contained number of job losses rather than prohibiting the transaction. So I think that's the principle, that, jobs, or at least retention of jobs, or stemming the tide of job losses can indeed save a merger and allow it to go through when it may otherwise not. Right, so I think that brings us to the end of mergers. No, there's one more merger topic, sorry, that I wanted to touch on, and I'm going to try and do it very briefly because I see time is marching on and there's still a lot to cover. Just to put onto your radar screens that South African Amendment Act 2019, I think, introduced the notion of the presidential veto in relation to foreign direct investment transactions. This is similar to a CFIUS type piece of legislation like they have in the US, but essentially it's where you have a foreign acquiring firm that's acquiring a firm that was incorporated, sets up a presidential veto committee, is what I wanted to say to you, where you have a foreign acquiring firm or a firm that's incorporated, established, or formed under the laws of the country outside of the Republic, or whose place of effective management is outside of the Republic. So if it's a merger, as defined in the Competition Act, and relates to a foreign acquiring firm, then you will need to serve a notice on this presidential veto committee, still to be established, right? And it's only if it touches on one of the things that are in the national interest, national security interest. It is a parallel process that will run parallel to your merger process through the competition authorities. It has been criticized for various reasons. One, it is fairly broad, and there is no real clarity as to, sort of what constitutes a national interest, a national security interest. They're the usual things, like security and infrastructure and things like that. But it has also been sort of fairly broadly cast to include things like the supply of critical goods or services to citizens, or the supply of goods or services to government, or supply, the impact on the economic and social stability of the country. So it has the potential to be very broad and very far-reaching. It also has the potential to be open to abuse. But we are awaiting the regulations that still need to be promulgated. The regulations will deal with the time periods and processes, etc. It's not yet in force, but it is something to keep an eye on, because I think it is going to impact particularly foreign direct investment, and create an additional sort of regulatory hurdle that we're not facing currently. One final thing just on mergers is just to touch on an increased focus on cross-shareholding and information sharing issues arising in mergers. So that is where you may have a shareholder holding interests into businesses that compete and managing information flow between them, particularly if they don't form part of a single economic entity. The Commission is fairly focused on that. Some of you may remember we did a seminar on that a few years ago. It does remain a hot topic and also just something to be alive to, and keep an eye on. One last bit on mergers for those who are very interested in the legal nitty-gritty of issues is just to put on your radar the HCI case in the Constitutional Court, which dealt with the concept of control and the principle of bright lines. In short, the case found that a change in the quality of control doesn't constitute a merger. This case has been the subject of massive debate, and there's not completely uniform acceptance of it by all stakeholders, but I'm just putting on the radar that sort of some issues around change of control have been considered by the courts in the last little while. Okay, I am now finished with mergers, and I'd like to touch on some of the dominance issues that I mentioned earlier on. So I've already touched on some of the protections afforded to SMMEs and HDPs in the context of public interest in mergers. But there have been some recent developments in the amendments which came into effect last year aimed at protecting SMMEs and HDPs in relation to the dominance provisions. I'm raising it at a very, very high level. I know that some of you in the audience have sought very, very specific and detailed legal advice on this. It is particular to dominant firms, so I'm putting it on your radar screens particularly. The first is the new buyer power provision. So very briefly, the amendments and regulations prohibit dominant firms from imposing an unfair price or trading condition on SMME and HDP firms in specific designated sectors, such as agro-processing, grocery wholesale and retail, e-commerce and online services. So in assessing a complaint under the buyer power provisions, the Commission will consider, one, is the buyer dominant? Is the supplier an SMME or HDP? They'll look at the price or trading condition that's been imposed, whether the price or trading term is unfair. It is perhaps this final element that's most novel and requires some unpacking, right? What does unfair mean in the context of the Competition Act? So the Commission has published some guidelines that provide some benchmarks for determining if prices are unfair. And basically, if the price at which an SMME or HDP supplies to a dominant buyer is lower than the price paid to other suppliers, or the price previously paid to the same supplier for their product, such a price may be deemed unfair. The Commission will be particularly concerned about price differences that are sizable, have persisted for a reasonable period, and consistently discriminate against SMEs or HDPs. The guidelines provide that for screening purposes, the Commission will apply a 3% threshold to relative price differences. The guidelines also provide several indicators of where the Commission will consider a price to be unfair, including if the reduction was unilaterally imposed by the buyer without negotiation. Is it retrospective in its application? Has it been selectively applied to the complainant or suppliers within the designated class? Whether it lacks an objective justification, and whether it unreasonably transfers risks and costs onto the supplier that should ordinarily be borne by the buyer or distributed evenly between the parties. I see that I'm running short of time, and I do have two other topics to cover. So I'm not going to go into the detail of the guidelines on trading conditions, but I'm sure for those of you for whom this is particularly relevant, you know which questions to ask. But I did want to touch on the second amendment, which is the price discrimination provisions. So briefly, the section dealing with price discrimination by a dominant firm now includes a section in terms of which an action by a dominant seller is prohibited price discrimination if it's likely to have the effect of impeding the ability of SMEs or HDP firms to participate effectively in the market. Circumvention is prohibited also in that a dominant firm can't avoid or refuse to sell goods or services to an SME or HDP firm simply to avoid the operation of the new price discrimination provision. Another important amendment is that volume-based discounts are no longer available as a defense when dealing with SMEs or HDP firms. The justification is still available when dealing with other purchasers, just not in relation to SMEs or HDPs. Just to note that protection in terms of this new provision doesn't extend to an HDP firm that purchases at least 20% of the relevant goods or services supplied by the dominant seller. So just very briefly, the elements to establish a case of price discrimination in this regard: the selling firm must be dominant in relation to the goods or services that are the subject of the complaint. There's differential treatment between the purchaser in the designated class and other purchasers outside of that class, in respect of equivalent transactions for goods and services of like grade and quality. And note that the differential treatment can be on price, discounts, rebates, credit given, etc. And three, there's no available defense to the differential treatments, so including that there's no reasonable allowance for differences in supply costs based on location, methods of supply, etc. And four, the price differential relative to other purchasers impedes the effective participation of a firm or firms in the designated class of purchasers. Obviously, very, very difficult to prove. So as you can see, fairly detailed analysis required to assess this section. Some of you are already looking at this in a lot of detail, I know. And as I say, if you have any specific questions on that, you know where to find us. I want to touch very briefly on cartels, and I do still want to get very briefly to the digital economy if we can get there. So I'm going to try and race a little bit. Just at a high level, between 2016 and 2019, the Commission has extracted more than 2 billion rand in cartel fines. There are a number of large ongoing cartel cases. There's the LPG complaint relating to alleged price fixing against several firms in the liquid petroleum gas industry. There is the Contractors Plant Hire Association, where the Commission has referred against 22 of its members to the tribunal. Basically, that was an investigation in terms of which the Commission found that members of the CPHA agreed to fix the minimum hourly and daily rate charged for the rental of their machinery and plant equipment, and potentially fixed trading conditions relating to the renting of the machines. So there are a number of large ongoing cartels. There has been a slowdown in trials. During COVID, the Commission and tribunal suspended these matters, and we are waiting for them to get back on track, and we are expecting during the course of next year for some of these things to go to trial. But apart from the ones that are pending trial, there have also been lots of settlements involving various cartels, various parties fined. I've listed a couple for you there in the slides. Most notably, I suppose, in the FMCG space, South Africa's 14-year-long maize milling cartel is also now nearing its conclusion. The Commission's tribunal has confirmed the Commission's settlement agreement with GWK Farm Foods in respect of fixing prices of white maize products between 1999 and 2007. This was the 14th and penultimate settlement agreement in the cartel, which really also illustrates the importance of the Commission's leniency program. The Commission began investigating the cartel in 2007 after it received leniency applications from Premier and Tiger. Went on to find that 17 companies in the white maize milling market colluded to fix prices. So in March 2010, the Commission asked the tribunal to fine the companies, apart from the 2 leniency applicants. The Commission reached its first settlement agreement a month later and now has settled with 14 companies for, sort of 650 odd million rand. But leniency has and continues to play an important role in the busting of cartels, but it has been dampened somewhat by the criminal sanctions that can now be imposed, which we'll come to in a moment. Just to touch on what's happening sort of more broadly, the International Competition Network, of which our commission is a member, has also recognized the importance of leniency policies in uncovering cartel conduct at a broader, more sort of a regional level. And last year, they published guidelines on enhancing cross-border leniency cooperation, which is obviously a first. So what it's intended to do is to provide practical advice for competition agencies to assist them in engaging with other jurisdictions on matters involving multi-jurisdictional leniency applicants. So it's aimed at making international enforcement efforts more effective and helping to reduce disincentives for prospective leniency applicants. These guidelines make 3 recommendations, namely confidentiality of leniency applicants' information, transparency when dealing with other competition authorities, and coordination with other competition authorities. So although the guidelines are not binding, they're sort of a cooperation instrument, which the ICN members are not required to implement, but usually held in fairly high regard, these kinds of instruments. So even though they're not binding, they may well serve as a sort of springboard to intensify cross-border leniency coordination and cooperation from the various African ICN members, and serve as a step towards identifying and combating multinational cartels across the continent. This is something we haven't seen really much of, so quite important for companies that are operating across the continent to please take note. Just to touch very briefly on the criminal sanctions, criminal liability does now exist in South Africa. It's been around for about 4 years, but we are yet to see a prosecution. But essentially, a manager or director who either was responsible for the cartel or knowingly acquiesced to the cartel can be personally prosecuted. People who have to do the prosecuting is the national prosecuting authorities, and we maybe haven't seen any prosecutions as yet because maybe they have difficulties or training is required, or we're waiting some regulations, but it does exist. And once we start seeing our first criminal sanctions, it would put South African cartel enforcement on a par with other jurisdictions, such as the US, where sanctions have long been operable. Right, so I have only 8 minutes left. So I would like to touch on 2 aspects of competition in the digital economy. Firstly, I'm not a data protection lawyer. Obviously, I'm a competition lawyer, but since digital markets and platforms are expected to continue to dominate the antitrust debate for many years to come, I think it's important, we all acknowledge the intersection between competition law and data protection has become increasingly important as a topic that's being recognized by many competition authorities globally. Past month, our commission and the information regulator concluded an MOU for the purposes of strengthening cooperation between them and sharing information between the 2 agencies. So the MOU sets out the manner in which the commission and the information regulator will interact with each other to enable them to effectively coordinate jurisdictional issues. I have a lot more detail on that, but I think I'm going to press on a little bit. But even prior to the MOU, the role of data and digital markets has been the subject of increased focus by the Commission. Towards the end of last year, they published their digital economy paper. It's got a longer title, but we all refer to it as the digital economy paper, signaling the Commission's increased focus on the use of data, artificial intelligence, and algorithms in the competition sphere. It's very much in line with international trends, and many similar papers have been issued by foreign competition regulators. The Commission's paper looks at, sort of proposed solutions to the issue of whether the existing antitrust toolkits are sufficient to deal with issues raised by the digital economy, or whether new alternatives are needed. The digital economy paper acknowledges the benefits of online products and services, but notes that the Commission is concerned about this sort of winner-takes-all nature of some of these markets. particularly for search, shopping, social media, things like that. So it's looked at, a need to focus on new theories of harm, such as self-preferencing. So that's when a vertically integrated firm benefits from both owning a platform and trading on that platform in competition with other sellers on that platform, or using their control of the platform to give preferential treatment to their services over the services of other companies. So things like that. Things like personalized or targeted pricing, which is using consumers' data to facilitate price discrimination and predatory or excessive pricing in some instances, based on what the data indicates, a consumer is prepared to pay. So there are a number of other issues that it touches on, but the most important one that I want to sort of focus on very, very briefly is the digital inquiry that the Commission has launched subsequent to this digital economy paper. I'm sorry I'm rushing through this, but there is a great deal of information on this. If we can just go to the next slide. So the Commission launched a market inquiry into online intermediation platforms, which is currently ongoing. The hearings are happening as we speak. So essentially, the scope of the inquiry is on business to consumer online platforms, and in particular, features that might restrict platform competition or which relate to competition amongst and fair treatment of the businesses that use these platforms to list and sell products, but most particularly SMEs and businesses owned by HDPs. So the digital market inquiry will look at a more focused investigation in 5 online platform categories, mostly, namely e-commerce, delivery platforms, travel and accommodation, online classifieds, and app stores. So the Commission has already identified a number of the key issues that it wants to look at in these categories, looking at the extensive and growing use of sponsored rankings, its impact on consumer choice, discoverability of small or historically disadvantaged businesses on these platforms. There's a number of issues are articulated, and the Commission has also already identified particular companies which it views as sort of market leaders in various sectors, such as Takealot in e-commerce, for example. The Commission will be paying particular attention to these companies in their submissions. Importantly, foreign-based online platforms that facilitate transactions with South African consumers or businesses also fall within the scope of the inquiry, even if they've got no presence in South Africa. And the Commission has also reached out to businesses that make use of these online intermediation platforms to understand their experience, in particular the extent of platform dependency, the restrictions placed on their businesses by platforms, the perceived fairness of search algorithms, platform terms and conditions, and a multitude of other things. I think we have now run out of time. I think that concludes our very whirlwind tour of competition law over the past 18 months. I hope it's put some of the sort of most pressing issues into the forefront for you, and you know where to find me if you have any questions. So apologies that we probably don't have any time to take questions, but I know that Michael is ready for his session. Thank you.
Thank you very much, Jocelyn. Like you said, I think attendees know where to find you. It was very interesting topics that you actually covered, and very, very crucial to understand what's been happening in our landscape in the last 18 months.